Welcome to You and the Law. I'm Steve Cilente.
And I'm Bob Lally.
Bob, we've had some questions from viewers regarding the court system.
Right.
And there's more to the court system than probably most people think about. So what are the different types of courts and how are they different is going to be our subject today. We're all aware that there is a federal court system which actually originated from English common law. In fact, post-revolution, that's the law that most people understood, so that's essentially what they carried on. But because we now had separate states, each state tended to set up their own law.
Each state had to set up their own system, and most of those were based on common law. In England, that's why we have so much time devoted to it, say in the study of law school is based on the common law. In fact, we read a lot of Old English cases.
And that was primarily the civil
codes and the statutes, and they evolved from old cases that kept occurring over and over that they relied on.
And interestingly enough, Louisiana is kind of by itself because, as everybody recalls, we got that into the Louisiana Purchase, which was under Napoleonic law. So as a consequence of the 50 states, the Louisiana law is based upon French and Spanish codes and to some degree Roman law.
I didn't know it was Spanish and Roman. That was a new one. I knew French.
Yeah, they are a little bit different. I've actually had the opportunity to work with an attorney from Louisiana and talking to him about some of the differences, and very interesting. But as we grew as a nation, obviously there had to be some changes.
Right. I do remember Louisiana law. That was the one thing the professor says that's completely different from what you're going to learn. There had to be a unified system that was needed to regulate where the laws conflicted, as we evolved as a nation. And the laws had to be determined, if they were going to be valid in which state, and they arose, different states had different laws and conflicting laws. And they would conflict with federal law as well.
So that's where the federal court system was in part set up to make the laws similar between the states to essentially, as some people might say, wrench control away from the individual states to develop their own court systems.
Well, there's a big thing about states' rights, as you know, and I think we talked about that on another show, but the federal courts generally were created by the United States Congress and the Constitution. I think it's Article 3. And many were specialized and granted authority. I can think of one, bankruptcy, court of claims, things like that. And greater powers vested in Article 3 because they're independent of the Congress, the president, and the political process. They're a separation. That's one of our three powers of separation.
The separation of powers, of course, is the Congress, the executive branch, which is the president, and of course the judicial. And the idea was that they would be completely independent, so one could not control the other.
That's right.
But we know that there's some control a little bit between them.
They call it checks and balances.
Yes, I think that the Congress, for instance, sets the pay for everybody else.
That might be an influence, but it hasn't been.
Right. So we've got a Supreme Court under the federal court system, but there are other lower courts, are there not?
True. There's appellate courts. There was a Supreme Court, and then they created other federal courts. And then they placed limits on their jurisdiction.
Okay. Now, it is the Constitution, and you're correct, it is Article 3, that established the Supreme Court. But it also permitted Congress to create other federal courts and to place limitations on what type of jurisdiction that they had. So Congress did have a little bit of control as far as the establishment of other courts.
Correct.
Okay. So in theory, though, isn't it correct that because of the Constitution-based Supreme Court, that Congress could essentially eliminate everything but the Supreme Court?
They could if they desired to, but we would have a backlog of cases in the Supreme Court.
Exactly. Now, it was actually, I think, the first Congress that established the system of lower courts, and it goes back to the Judiciary Act of 1789. So it's been around for a while. I don't see them trying to get rid of the lower courts. What about our California Constitution? Now, one of the things I remembered from my own independent study is that originally much of what we adopted was under the Field Code, as I recall. I hope I'm right.
The Field Code?
Field Code.
Okay.
But as everybody recalls, we got an early start, 1849, gold rush, etc. And in September of 1849, in advance of us California becoming a state, there were 48 delegates that assembled in Monterey, which was the first capital, to draft, I think it was the first capital, but to draft the very first state constitution. Now, ironically, then, and as I understand now, California state constitution is one of the top 3 longest constitutions in the world.
Was it longest then or now?
I think, well, even though there have been some acts to try to reduce that, I still think we're up there as far as being the longest. But Article 4 of the new Constitution was created, covered the judicial branch, provided for Supreme Court, and at that time, 1 Chief Justice and 2 associate judges. There were only 3. And at that time, they were elected by the state legislature initially, and subsequently the justices would be elected by the voters for 3-year terms.
Correct, yeah. The justices of the Supreme Court, the California Supreme Court.
That's all that existed at that time.
That's, okay.
Right. But there were changes that followed, correct?
There certainly were, because I was thinking in my mind the modern day is how it is with the appointments.
Right. So first change we saw was what, 1862?
Yes, it was amended to expand the category of cases that the court could consider and to increase the number of Supreme Court justices on the court from 3 to 5. And the terms of office were extended from 6 to 10 years.
So unlike today, they were shorter, much shorter terms, and certainly with only 3 justices hearing all of the cases, it may have been a little bit more difficult. But that wasn't the last change. Obviously, California was growing very rapidly and cities were being formed. In 1877, they again asked for a revision of the Constitution. And it took about 2 years. They were finally ratified in 1879. There were major changes. California's Supreme Court was expanded, now a Chief Justice and 6 associates. And the terms were then lengthened from 10 to 12 years, which is the current term of 12 years. And interestingly enough, the Constitution required that all of their opinions be in writing. I wasn't aware that some of the early opinions apparently were just oral.
So we don't know what those were because those probably weren't tape recorded.
Or they weren't written down. I'm sure they weren't tape recorded. But it's interesting. I've actually, and I don't recall what it was, looked at case number 1 in the state, and I think it dealt with mining rights or something like that. But it'd be interesting to know what opinions were not recorded.
Well, in 1904, 3 courts of appeal were created to help handle the backlog because we started growing as a state.
Obviously, with just having 1 state court, it would have been a little bit more difficult. Now, what we don't know, and we understand that there were other courts. We've heard about circuit court judges that moved around from court to court. Some of these were perhaps vigilante courts, but there was only 1 official court at that time, recognized by the Constitution, that is, and that was the Supreme Court. Well, things stay.
Vigilante courts, they had jurisdiction?
That goes into the issue of, I once taught a class on the how law developed, and they all start with tribal law and essentially vigilante law. But in any event, once that last change was made in 1904, we pretty much stayed the same for the next 70 years. When finally we had created justice courts. They're not constitutionally created, but they were created. And there were a lot of justice courts throughout California. Every little town seemed to have a justice court. And interestingly enough, you did not have to be a lawyer to sit as a justice court judge. So,
What qualifications did you have to have? I'm just curious.
breathing, I believe, that was about it. But there was a landmark decision in 1974 that said it was a violation of due process of law to allow any non-lawyer to hear a case where a person could be incarcerated. And that was a major change. At that time, my family was living in Shasta County, and all these little towns had their justice courts. They virtually went away overnight. And now they were looking for attorneys to fill some of these spots, and eventually many of them were just closed down to consolidate the courts primarily in the county seats.
Well, I can remember that a lot of them were grandfathered in, weren't they?
If they're an attorney.
Oh, interesting.
And without saying who it is, there's a judge that periodically sits in this county as an assigned judge who, as I understand it, was one of the original justice court judges. And as I understand it, that he got elected right out of law school. And then as the court system changed to what we have today, he was grandfathered in from a justice court judge, but because he was an attorney, he moved up through the system.
He's been doing it a long time then.
And now retired, but occasionally visits us as an assigned judge.
Interesting.
So, but that wasn't the last change.
No, in 1998, California voters amended the Constitution to allow trial courts to unify their courts. And basically the Superior Court and the Municipal Court became one court, and all the Municipal Court judges and the Superior Court judges, boom, they got cross-designated.
Exactly.
So they had all equal status and could do the same type of thing.
In our small counties, a lot of us, the counties still had justice court judges. They were also grandfathered into the Superior Court judges. So now, certainly in Calaveras County, we have only 2 Superior Courts and occasionally a 3rd court. But everybody is a Superior Court judge now.
Yes, they're referred to as Superior Court judges because before you had municipal and Superior Court judges. But they're always called Your Honor.
Absolutely. Well, at least to their face. Now, federal courts are a little bit different. What constitutes like a federal case?
Well, let me talk about that a little bit, some specifics here. First, you have to have a federal question. For example, it has to be a federal law or a federal statute or something of that nature. And there has to be a question. It can't be moot. I mean, there has to be a real question to decide.
Moot meaning that essentially it's already decided. You don't need us to confirm what's already been done.
Right. It's still an issue.
Yeah.
It's still an issue. And then there has to be complete diversity, and that's a term of art where there has to be people from different states. And that has to exist at the time of filing, when the complaint, that's the initial thing, or the petition is initially filed. And that, for residents, you look for personal presence plus an intent to remain. And it gets a little specific here. For corporations, that's where the corporation was organized or its principal place of business. Now, what's interesting about this is if you could be going along and complete diversity can be destroyed. Like one of the party gets realigned or one party gets moved to the other side, you no longer have complete diversity. But in addition to having complete diversity, you have to have the minimum amount in controversy, which means exceeds. And notice I use the words exceeds. $75,000 exclusive of interest and costs. That means the amount of controversy. And that could be attorney's fees if it was part of the damages. not costs or something like that. And it can also be punitive damages. But punitive damages, when they looked at in that situation, are looked at kind of skeptically as to whether it's going to be, because they have to look ahead and see what might be awarded. But in venue, that could be usually where any of the defendants resides. Yeah, go ahead.
Interestingly enough, and we're not covering it for today's program, is that there are other courts that are outside of the usual court system that we're talking about today. And one of those are tribal courts. A number of different Indian tribes or Native American tribes have their own court system developed on their laws. And in one of my recent experiences, the tribal court opted not to prosecute a case and turned it over to the state court, but they could have chosen jurisdiction over that case if they had chosen.
And that would have been binding, correct?
Absolutely. Essentially, they're a separate nation within our nation, and if they said we want this case, they would have. There's nothing anybody could have done about it.
And I'm kind of curious, what rules of evidence would have applied?
I never got that far, so I don't know.
Okay.
I would presume, however, that they probably follow federal rules of evidence, but it's only a presumption on my part. Well, we know the federal system is out there. Most of us don't deal with it. A lot of attorneys, they practice only in federal courts, and a lot of us only practice in California courts. So in dealing with the California courts, this being the century that we're in, some years after the creation of California, how are we currently comprised in California?
Well, we have one Supreme Court, as you know. That's why it's called the Supreme Court. In New York, the Supreme Court are the trial courts, but Supreme Court here is our highest level. And there's 3 different locations. There's one in San Francisco. I should say they travel. They're only at one location at the time, but 3 main locations, one in San Francisco, one in Sacramento, which is the oldest building, and then one in Los Angeles. And sometimes they'll go to another city or so. They'll designate themselves. But that's usually the 3 that they hear the cases in.
I think you and I both were in, I don't know about you, but I was at the Supreme Court building.
I think so.
Yeah, when I became a lawyer. Now, all the other state courts in California have to follow any published decision of the Supreme Court. Now, we both know as attorneys that there are times the Supreme Court will issue an opinion. It's in writing, but they'll declare it depublished. You may be able to find it, but we can't use that as setting any precedence under the law.
They get upset if we do.
Certainly, somebody does. And the justices of the Supreme Court, as we saw very recently, are appointed by the governor, but they must be confirmed by the voters at the next election. And that's every 12 years that they come up for. It's actually confirmation or reconfirmation. They're not there campaigning against anybody else. If you decide you want to be Supreme Court judge, you can't run against them.
No.
You have to first be appointed on the bench.
Exactly, and then you're confirmed. We saw this situation with Rose Bird some time ago.
Right. And she was not reconfirmed.
No.
So now, are there any particular qualifications that you're aware of that you've got to have to be a Supreme Court judge?
Well, you must be a lawyer. This is kind of interesting, must have passed the California bar exam. And this is a bit wordy. Or, there's an or in there, pass the California bar exam or have served as a judge of a court of record in California for 10 years prior to their appointment. Now, can you tell me what that means?
I don't, because in order to be a judge, you've got to be a lawyer. To be a lawyer in the state of California, you've got to have passed the bar. Now, ironically, perhaps what it is if you were licensed in another state and you practiced in the federal courts only, which is okay, then that may constitute 10 years of practice. Mm-hmm. I don't know. I've never seen that situation. All right, Supreme Court. Can you just file any kind of action in Supreme Court?
No, it doesn't start in the Supreme Court. It works its way up there. But they do have what's called original jurisdiction in proceedings in extraordinary relief in the nature of, and these are where you get into the words that are hard to pronounce, mandamus, certiorari, and prohibition. And the court has original jurisdiction, that's beginning jurisdiction in habeas corpus proceedings.
We're not going to get into the Latin things, and some of you may recognize what a mandamus, certiorari, or prohibition are, but they have certain areas that you can go directly to them. It also gives them the ability to review the cases heard by various courts of appeal. And once they make a ruling, that is then binding on all California courts, and which we'll hear is different from what the Court of Appeals can do. But in looking at a case that's come up on appeal through the system, the Supreme Court can decide the entire case or just take a selected issue from the case and not decide other issues that may be present.
Can they publish just parts of it?
Absolutely. They can pretty much do what they want to do. So, what's the Constitution also say about our High Court?
They can have to review all cases in which there's a death penalty involved and it's been pronounced by the trial court. And these cases are automatically appealed directly from the trial court to the Supreme Court. They bypass the Court of Appeal.
In fact, the Court of Appeal specifically cannot hear them.
Correct.
Okay. In addition, the Supreme Court reviews recommendations of the Commission on Judicial Performance and the State Bar concerning discipline of attorneys and judges. So if there is an issue, obviously we see it with attorneys and periodically with judges, it goes right to the Supreme Court.
And the only other matters coming directly for the Supreme Court are appeals from decisions from places like the Public Utilities Commission.
Which is really unique in California.
It is.
If you've got a Public Utilities Commission issue, it doesn't go through the appellate process, goes right to the Supreme Court.
It's kind of an entity unto itself.
Exactly. In California, there are 6 courts of appeals, and every Superior Court is within one of the 6 districts. The districts include San Francisco, Los Angeles, Sacramento, San Diego, Fresno, and San Jose. Now, we've got 6 different courts. We're in the 3rd district, which is in Sacramento. What decisions or what laws are the appellate courts bound by?
Well, they're bound by the California Supreme Court and the United States Supreme Court and the United States Court of Appeal. It's kind of interesting. It's usually discretionary, but if it's in the district of the United States Court of Appeal, it will generally give it discretion and follow it or give it close scrutiny.
But they don't have to.
No. It's the one other thing, if there's a split in the courts of appeal, then, but we're not talking about trial courts yet, are we? Okay, we'll hold on for that.
Okay. But they can take a look at whatever the Federal Court of Appeals say or district courts, and if they choose not to follow that particular federal ruling, they don't have to. But they
That's right.
certainly, if a case is going to the Supreme Court of the United States, they must follow that.
They must.
Okay. Now, the role of the appeals courts in California they don't do trials from the very beginning. They only handle appeals, in other words, a review. And what they're reviewing are the Superior Court cases that have worked their way up through the appeal. The court files, the transcripts to decide what, if any, legal errors are created. There's a process to this, isn't there, Bob?
Yes, to do this, the Court of Appeals they hear arguments from each side. Well, first a notice of appeal is filed, as you know, and there are certain time guidelines, but it applies differently in different cases, so I won't get into it. But they can hear arguments from each side, and then each side has a chance to make a presentation. And surprisingly enough, there's a real discussion session where the judges ask questions. It's more of a discussion session if you've ever watched one than anything else.
I understood it was more of a grilling.
That is correct. That's correct. And they call it oral arguments, but it is more of a grilling, like having a deposition taken, for example. But the oral arguments are open to the public, but there are no juries or witnesses. They're just talking about the law and the facts.
And in those cases, the appellate court can decide not to have any oral testimony at all, to just go off of the written record, correct?
That's correct. That's correct.
It's up to them. It's what they want to do. And as we said before, the Supreme Court decides all death penalty cases. The courts of appeals are not involved. Well, there are 58 counties in California. Each county has their own court system, which come under the Supreme Court as well as the Court of Appeal. Where are we today, Bob?
Well, that's where we were talking about the merger earlier. We had the municipal court and the superior court merge for economic reasons. They thought it'd be more economic to administer one court system instead of two court systems, basically. And it absorbed judges of the peace that were talked about, that were grandfathered in. And municipal court judges and superior court judges that we talked about got cross-designated. That means that they could each do each other's duties, so they had more judges available. And each county superior court has a presiding judge, and it's kind of interesting because the presiding judge is either elected or chosen by his peers, the other judges in that court. And some get asked rather, often. But I've seen them come back, sort of a year and then come back. But they get elected or they're chosen.
The presiding judge is kind of like the supervisor of all the other judges.
Right,
Now,
he's the administrator.
but I notice in the smaller counties where you only got 2 judges, they tend to alternate back and forth in many of the counties.
Correct. And they share the duties.
It's kind of hard to, what do you do with there's a 1-1 split in a 2-court sit? Never mind.
And nobody to cast the vote.
In most superior courts, you see 4 different breakdowns of the areas of law that the courts handle. Civil, criminal, which includes misdemeanors and felonies, family law, and probate. Now, there are some other areas of law that, like small claims, that we often hear landlord-tenant law, that are incorporated somewhere within these 4 categories. What about terms? How long do our Superior Court judges sit?
Well, it's kind of interesting. They're elected or appointed. They can be elected, they can be appointed midterm, but they serve a term of 6 years. And then they have to run for re-election at the end of the term unless they're lucky enough not to have anybody run against them.
Now, in the Superior Court system, you can actually run for, as a lawyer, you can run for a Superior Court judge position and bypass the appointed process, correct?
Yes, that's correct. But you might be coming in midterm. You might have to run again in another year.
Not if you're running at the election.
That's true. That's true.
Right.
I'm thinking if a judge retires or something like that.
Yeah, normally they do that midterm and let somebody get appointed.
That's true.
In the Supreme Court or Superior Court system, they obviously have to follow all of the California codes and statutes, all the appellate decisions of all the U.S. Supreme Court decisions, all the California Supreme Court decisions. Anything else?
Yes, the California Courts of Appeal, and this is what I started to talk about earlier because it's always intrigued me. There's a case called auto equity. But if there's a split in the Court of Appeals in California, the trial court can follow whichever one it likes best. It can go, as long as it hasn't been resolved by the Supreme Court, it can follow either Court of Appeal, the decision from either Court of Appeal.
And oftentimes when cases go up to Supreme Court is because there's a split between the various courts of appeals. In our discussion today about the court system, while it may seem confusing, we even have sometimes tried to figure out where a case should actually go. We're primarily dealing with our local courts, our superior courts, and only in rare instances does a case qualify for federal courts. Don't feel overwhelmed by the system. They're trying to make it better. Go to the court's website when you have time, take a look. Thank you for joining us today on You and the Law and You.